Been a really interesting summer with a few interesting cases, and our shipping news seminars we try and pull together the latest, most interesting cases so that we can share with the industry the developments in shipping law. Tonight I'll be talking about two cases, one a Hong Kong case, one an English case. The Hong Kong case is called the Alas, which is named after the ship. And the interesting development out of this case is about whether or not a ship can be arrested to enforce an arbitration award. The other case that I'm going to be talking about is called the Bao Yue, which is an English law case, and it's about whether or not a lien exercised in a bill of lading for the storage charges for cargo discharged at the discharge port is effective or not.
I'm going to deal with a very recent shipbuilding dispute case law. It was a decision was made in 2015 this year, and judge in that case deals with delays, all the kinds of delays under the shipbuilding contract. He analyzed permissible delays, non-permissible delays, excluded delays, and buyer's breach delays. And this judgment is a good guidance on buyers when to cancel the contract, which deals with like hundreds of millions of money. So it could give a very good guidance on buyers and shipbuilders when to cancel or not. So it will be very, very good guidance. Because in this case, judge, as I mentioned before, analyzed and set it out 4 different delays under the shipping contract. As I mentioned, permissible, non-permissible, exclude delays, and buyer's breach delays. And judge made it clear which is allowed, which is not allowed. So shipbuilders and buyers know, they exactly precisely know when to cancel the contract, which is normally like a 70 million or 100 million. So it's a good guidance to parties in a shipbuilding contract dealing with their contractual termination rights. So it's very, very useful. And I think every shipbuilder and ship owners, we must memorize this case.
The key takeaway really from the case called the Alas is about whether or not a right to arrest a vessel survives an arbitration award. So the question of whether a maritime lien or a claim in rem survives the crystallization of a claim into an award or a judgment. And it's a very important decision in Hong Kong, because it confirms that, yes, in fact, where an arbitration award is made in relation to a claim in rem, that claim in rem continues to exist, and therefore the claimant continues to have a right to arrest a vessel in Hong Kong. This is a change from the perceived situation under the law, which is that a vessel cannot be arrested for enforcement of a judgment or an arbitration award. In the second case, the importance is really about the delivery of the bill of lading and who has the rights under the bill of lading and who is responsible for them. The interesting fact is, of course, that the ship owner continues to have a right to be paid for the claims that he's made in respect of storage costs that arose under the bill of lading. And the shipper cannot hide behind the fact that the bill of lading was never delivered to the receiver in order to make a claim against the ship owner for conversion of his goods.